Please be seated. Vous vous asseoir.
We will continue the submissions of legal representative of cross-border victims. Your 20 minutes begins now. Please proceed.
Thank you very much, Mr. President, and Your Honours. May we please start today in the same spirit as our submissions of yesterday, and to again express our genuine gratitude on behalf of our cross-border victim clients for the OTP's indication in their reply yesterday that in the event of the pre-trial chamber's decision being reversed, the incidents that the cross-border victims complain of may, to quote the prosecution, may properly be captured in the parameters of any future investigation. While that is encouraging, we note that the OTP limit themselves to stating that the incidents may be captured in a future investigation. Our concern is that for as long as the OTP hold back from making a decision one way or another about the distinct category of victimization that our clients fall within and the potentially different jurisdictional issues that arise, the cross-border victims are effectively denied either the comfort of knowing that the crimes that they complain of will be investigated, or an opportunity to make meaningful representations pursuant to Article 15, subsection 3 of the statute. And importantly, they are denied the knowledge that the OTP's decision, if negative on the interests of justice, will be and must be reviewed by the pre-trial chamber pursuant to Article 53, subsection 3b. Article 53, 3b provides that a decision by the prosecutor pursuant to Article 53, 1c or 2c that an investigation would not serve the interests of justice shall be effective only if confirmed by the pre-trial chamber. Moreover, it is noteworthy that Article 53.1 provides that the prosecutor shall, having evaluated the information made available to her, initiate an investigation unless she determines that there is no reasonable basis to proceed under this statute. In determining whether to initiate an investigation, the prosecutor shall consider A, whether the crime is within the jurisdiction of the court, has been committed, whether the case would be admissible under Article 17, and C, whether an investigation would not serve the interests of justice. We respectfully submit that these are considerations that the prosecutor is obliged to take into account in relation to information made available to her. The cross-border victims have made information available to the OTP. We therefore submit that the OTP is obliged to make a decision on it one way or another. The concern we have is that no decision is in many ways worse than a negative decision, because it leaves the victims who have provided information to the OTP in effective limbo, not able to have the comfort of an investigation, but also not able to make and properly comment upon or challenge it. That, we respectfully submit, cannot be right. This is why we highlighted yesterday the vital need and importance of transparency by the OTP, because if neither the victims nor the pre-trial chamber have a clear understanding of the OTP's view about a particular group or category of victims and the crimes they have suffered, how can the pre-trial chamber make an informed decision, such as on the interests of justice, or whether the particular crimes fall within the jurisdiction of the court, as the pre-trial chamber is obliged to consider pursuant to Article 15.4. Turning to the Group C questions, and question A, the interests of justice. We respectfully support the submissions made by the prosecutor and other groups of victims on this issue, as we have set out in our written submissions of the 15th of November 2019. It is obvious, and a plain reading of Article 53(1)(c) demonstrates that determination of whether an investigation would not serve the interests of justice is a matter solely for the prosecutor. The pre-trial chamber does not itself have the power to consider factors under Article 53(1)(c) as justification for refusing to authorise an investigation. Article 53(3)(b) only provides the pre-trial chamber power to review a decision of the prosecutor not to proceed solely on the basis of either 53(1)(c) or 2c. It does not give the pre-trial chamber power to make the decision itself, and it is very clear, we respectfully submit, why this should be so. The prosecutor is plainly best placed to evaluate the future availability of evidence and the prospects of future cooperation. And plainly, the prosecutor is best placed to determine the impact of an investigation on finances and human resources, taking into account and evaluating the prospects of all other potential situations and investigations that she may well have exclusive knowledge of. It is the prosecutor who receives communications regarding potential crimes and situations within the jurisdiction of the court. Thus, it is the prosecutor who is in a unique position to determine the resource implications proceeding with one case over another. It is therefore obvious, we respectfully submit, that it should fall first to the prosecutor to determine whether or not it is in the interests of justice for an investigation to proceed. But, and it's an important but, this is not to say that the pre-trial chamber has no role to play. Far from it. We submit that the statute makes clear that where the prosecutor decides not to proceed with an investigation on the basis that it is not in the interests of justice, Article 53(3)(b) gives the pre-trial chamber a supervisory role. The prosecutor's decision not to proceed can only be effective if confirmed by the pre-trial chamber. The OTP, in this case, was completely silent on its position regarding the cross-border victims in the November 2017 request for authorisation from the pre-trial chamber. And notwithstanding the OTP's helpful indication yesterday, it is still unclear as to whether the OTP considers the alleged crimes to fall within the Afghan situation, the crimes that we presented in relation to the cross-border victims. We submit, obviously, that they plainly do. But the OTP is silent as to whether a prosecution is not in the interests of justice pursuant to Article 53(2)(c). And in not setting out the position, the pre-trial chamber is denied the possibility of exercising the important supervisory role that is entrusted to it under Article 53(3)(b). That said, we readily acknowledge that there may be circumstances when it may be appropriate for the OTP to protect the confidentiality of those who provide information to it and refrain from making public activities under Article 15 of the statute. That, however, is not the case here. The cross-border victims made public the information they had provided to the OTP. It is referred to in a hyperlink at footnote 21 of the 15th of November 2019 submissions that we made to the Appeals Chamber. Those were the submissions that were publicly available and were also given to the OTP in 2014. There was, therefore, no compelling reason for the prosecutor not to identify them and the distinct category of crimes and victimisation that they have suffered in the November 2017 request to the pre-trial chamber. Turning then to question B in the Group C questions. The pre-trial chamber plainly exercised its discretion improperly in holding that it was not in the interests of justice to allow the prosecutor's request. We make three short points. First, and most obviously, the statute and Article 53 does not give the pre-trial chamber the power to refuse investigation on the grounds that it would not be in the interests of justice. Second, the factors taken into consideration by the pre-trial chamber, the availability of evidence, the prospects of securing meaningful cooperation from relevant authorities, and the adverse impact on the court's resources, both financial and human, are all matters upon which the pre-trial chamber had not been fully addressed. How could it, therefore, make an informed decision? Third, with regards to the cross-border victims, we submit the position is even more profound. In the absence of any information about their situation, the availability of evidence, which is substantial, the prospects of securing meaningful cooperation, which is not inconceivable in relation to cross-border victims, some of the states allegedly complicit in the cross-border drone strikes are state parties to the ICC statute. At least 3 of them are identified in the 2014 submissions that were made to the Office of the Prosecutor. It follows then that the pre-trial chamber made its decision in the absence of and without considering their position at all, let alone did the pre-trial chamber fully and properly make a decision, because it could not do so. The information was not fully before it. Without the OTP's input on whether or not it would be in the interests of justice to proceed with an investigation to the crimes alleged by the cross-border victims, it was impossible for the pre-trial chamber to fully and properly consider the matters it was obliged to consider pursuant to both Article 15.4 and Article 15.3b of the statute. Group C questions, question C on scope. The cross-border victims agree with and respectively adopt the submissions of the prosecutor and other victim representatives that a pre-trial chamber may not limit the scope of an investigation to incidents specifically mentioned in the prosecutor's request. In this regard, may we please correct a significant typo at paragraph 39 of our written submissions, dated the 15th of November to the Appeals Chamber. The first sentence should read, the Appeals Chamber should further hold that Article 15 of the statute does not, we missed out not, restrict the scope of an authorised investigation to the incidents expressly identified. Nothing in Article 15 requires the pre-trial chamber to assess specific incidents and approve them for investigation. An investigation will inevitably develop over time. The approval sought for an investigation by the prosecutor under Article 15 will be at a preliminary stage. The specific incidents referred to by the prosecutor will most likely be illustrative or exemplary of a broader category of victimisation. The investigation must be able to develop and progress without any artificial restriction placed upon it by the pre-trial chamber. But the prosecution, in their consolidated response to the written observations of the cross-border victims and amici curiae, dated the 25th of November 2019, state at paragraph 18 that it is inconsistent for us on behalf of the cross-border victims to accept that the scope of an investigation is not limited, but also suggests that the prosecutor is nonetheless obliged to identify or make findings about alleged crimes concerning authors of all publicly known Article 15 communications. We respectfully disagree. We accept, obviously, that there may be reasons why certain incidents are included in a request while others are not. But where, as here, the OTP is provided with clear and compelling evidence of a distinct category of victimisation, potentially raising different jurisdictional questions, the OTP should express some view as to whether it intends to proceed with an investigation into such matters or not. In the OTP's consolidated response, again at paragraph 18, they state that identifying situations or making findings about all publicly known communications might also be counterproductive in requiring it to make an initial negative findings about certain allegations when she may, for various reasons, consider neutral silence to be the more appropriate course. We can see the force of that submission in cases where there has been an active and ongoing dialogue between the OTP and a group of victims, and where, for example, the OTP has expressed concern about the sufficiency of evidence regarding particular offences and given the victims an opportunity to address such concern, or where perhaps the OTP has explained in the spirit of transparency whatever concerns it may have about pursuing a particular line of investigation in relation to that category of victims. But in this case, and in relation to the cross-border victims, there has been no such dialogue. Since providing the comprehensive dossier of information to the OTP in 2014, the cross-border victims have received no communication from the OTP setting out its attitude to a very serious category of victimisation and the matters raised on behalf of the cross-border victims. Serious matters relating to a distinct category of victims with potentially different jurisdictional and admissibility questions arising from them and other victim groups that may be presented and contained within a request for authorisation. If there had been such communication or dialogue, the cross-border victims would have been better placed to decide what representations, if any, to make to the pre-trial chamber pursuant to Article 15.3. In the absence of any communication or transparency in the approach to be adopted by the OTP, it was impossible, and to an extent still is difficult, for the cross-border victims to know whether and what consideration has been given to the position of thousands of Pakistani-based victims by the OTP in its preliminary inquiry. In our representations via the VPRS to the pre-trial chamber on the 31st of January 2018, so after the prosecutor's November 2017 request for authorisation, but before the pre-trial chamber's decision on the 12th of April 2019, we expressly invited the pre-trial chamber to require the prosecutor to provide further information pursuant to Rule 50, subparagraph 4 of the Rules of Procedure and Evidence, and to clarify the position with regards to the cross-border victims. In our written submissions to the Appeals Chamber on the 15th of November 2019, at paragraph 36, we again highlighted the particular importance of the pre-trial chamber proactively and robustly using its powers under Rule 50, subparagraph 4, to request additional information from the prosecutor and from any of the victims who have made representations. That plainly did not happen in this case, and as a result, the cross-border victims were and remain in the dark as to the approach the OTP will take in relation to them going forward. We respectfully submit that is unfair and cannot be right. So to sum up, we agree that a pre-trial chamber may not limit the scope of an investigation to incidents specifically mentioned in the prosecutor's request, but where, as here, there is a large and easily identifiable group of victims who have presented clear and compelling evidence of a distinct category of crimes and victimisation by alleged victims in relation to the crimes they have suffered. The prosecutor should, having decided not to include them within any request, at the very least...
You have 2 minutes left.
2 minutes.
2 minutes.
I'm very grateful. Thank you very much. We respectfully submit that in those circumstances, the prosecutor should, at the very least, indicate to them what the position is going forward. It would be preferable, though, in the interests of transparency, for the view of the prosecutor to be expressly set out within a request for authorisation. If the victims are to be included within any investigation, that should be stated. If inquiries are ongoing, that should be stated. Alternatively, if the OTP has decided not to take the investigation, that should be similarly set out and stated, allowing, if necessary, the pre-trial chamber to exercise its powers pursuant to Article 53(3)(b) if the prosecution's decision is that the prosecution would not be in the interests of justice. Finally, in relation to the relief, in conclusion, we respectfully urge the Appeals Chamber to reverse the pre-trial chamber's finding on Articles 15.4 and Articles 53(1)(c) and make its own finding pursuant to Article 83.2 and authorize the investigation pursuant to Article 15(4). Additionally, we respectfully invite the appeals chamber to direct the prosecutor to provide clarity as to the intended approach to the complaints of the cross-border victims. The crimes they have suffered, we say, are so serious that they warrant an investigation, or at the very least, an indication as to why not. As ever, those representing the cross-border victims stand ready to assist the prosecutor with her efforts to ensure that the crimes that the cross-border victims have suffered are fully and properly investigated. Thank you very much, Mr. President, Your Honours.
Thank you, Counsel, very much. I would now invite the Office of Public Counsel for Victims to take the floor, address the Peace Chamber in the next 20 minutes. Please proceed.
Thank you very much, Mr. President. Your Honours, our submissions on the merit of the present appeal are largely in line with the ones presented earlier by the prosecution and counsel for victims. In the interest of time, I will focus on what we consider to be the most salient points arising from Your Honours Group C questions. With regard to question CA, we submit, and it will not come as a surprise at this time of the afternoon, that the pre-trial chamber did not have the power to consider the factors under Article 53(1)(c) of the statute as part of its decision under Article 15(4). As detailed in our written submission, the pre-trial chamber acted ultra vires in denying authorization based on its assessment that the proposed investigation would not serve the interest of justice. The decision authorizing an investigation into the situation in the Republic of Kenya, endorsed in subsequent proceedings, unambiguously confirms that only the prosecutor's assessment that an investigation should not be pursued, as it would not serve the interest of justice, can be subject to judicial review pursuant to Article 53(3)(b). By contrast, whenever the prosecution concludes that there are no substantial reasons to believe that the proposed investigation would not serve the interest of justice and proceeds to seek authorization under Article 15(3), a review of that interest of justice assessment by the pre-trial chamber is considered, to use the words of other pre-trial chambers in Article 15 proceedings, unwarranted. The statute as a whole makes the fight against impunity the court's very raison d'etre. Accordingly, the court's legal framework is based on a presumption that the investigation and prosecution of international crime are ipso facto in the interest of justice and should be pursued whenever the applicable jurisdictional and admissibility requirements are met, subject to one narrow exception. Indeed, Article 53(1)(c) allows the prosecutor, in highly exceptional circumstances, to refrain from initiating an investigation where there are substantial reasons to believe it would not serve the interest of justice. Given the overall presumption in favor of accountability, the drafters of the statute were careful to subject this narrow exception to judicial review to ensure the prosecution's limited discretion not to commence an investigation would not be abused. Hence, the dedicated procedure set out in Article 53(3)(b). By contrast, the statute contains no provision empowering a pre-trial chamber to review the prosecution's negative determination that there are no substantial reasons to believe an investigation would not serve the interest of justice. Since this is the default presumption position rather than the exception, and fully in line with the court's ultimate objectives, no judicial review of said assessment by the prosecutor is necessary. The wording of the relevant provisions in the statute also reflects this approach. Article 15.4 confirms that the pre-trial chamber shall, without any room for discretion, authorize the investigation whenever there is a reasonable basis to proceed. Divergent views have been expressed in this appeal as to the meaning to be given to the expression reasonable basis to proceed in the context of Article 15.4 and whether it covers each of the requirements set out in Article 53.1, including, in particular, the interest of justice. Given the extensive submissions already heard by the Chamber, I wish only to underline that the wording of Article 15.4 is far from clear and leaves significant room for ambiguity. Interpreting the reasonable basis to proceed in Article 15.4 as covering each of the three subparagraphs in Article 53.1, jurisdiction, evidentiary basis, admissibility, and interest of justice, would render the subsequent sentence that the case appears to fall within the jurisdiction of the court superfluous. Further, while the same English expression reasonable basis to proceed with an investigation appears in both Article 15.4 and Article 53.1, the Spanish and French version use different wording in each of these provisions. And while Rule 48 of the Rules of Procedure and Evidence creates a link between said articles, prominent commentators involved in the negotiations of the rule have noted that the reference in Rule 48 was, and I quote, carefully drafted in order not to capture the last sentence of Article 53, paragraph 1, which pointed to judicial reviews of the prosecutor's determination that an investigation would not serve the interest of justice. End of quote. The reference is to Freeman in the League Commentary on the Rules of Procedure and Evidence, Chapter 7, page 496. Accordingly, while the court's legal framework undoubtedly indicates that interests of justice are a consideration to be taken into account by the prosecution in deciding whether to request authorization to open an investigation, this does not necessarily entail a corresponding power of a pre-trial chamber under Article 15.4 to review the prosecutor assessment of this element. Even assuming arguendo that the pre-trial chamber was entitled to do so, the standard it applied in its review amounted to an error of law and an abuse of discretion. At most, the pre-trial chamber should have simply ensured that the requirement in Article 53.1c was met to the prescribed standard. Instead, the pre-trial chamber required a positive determination to the effect that the investigation would be in the interest of justice and relied on notions such as reasonableness and likelihood as opposed to the much more stringent substantial reasons to believe standard. Further, the pre-trial chamber engaged in a de novo review rather than treating the prosecution assessment of the interest of justice with a level of deference appropriate to any review of an exercise of prosecutorial discretion. Moving on to question CB, we contend that the factors taken into account by the pre-trial chamber when determining that the proposed investigation would not be in the interest of justice were not appropriate. Let me address first the pre-trial chamber's treatment of the interest of victims and the views they expressed in the representation submitted under Article 15 proceedings. The pre-trial chamber erred in adopting an unreasonably narrow reading of the interest of victims and in giving insufficient weight to the representation they made, particularly by the overwhelming majority of victims, who clearly favor the opening of investigation. The impugned decision wrongly interprets the interest of victims as effectively limited to and conditional on their participation in specific trials before the court. In fact, the interest of victims in the present proceeding, and also more generally, are much broader in scope and nature than mere participation at trial. Victims making representation before the pre-trial chamber refer, for instance, to ending the climate of impunity prevailing in relation to the relevant crimes, deterring further crimes, allowing victims' voices to be heard, and uncovering the truth. And empirical surveys conducted in different war-torn regions, including Afghanistan, confirm that the prevalent purpose for victims of taking actions against the perpetrators is to reveal the truth about the past. Logically, this interest can be pursued by the opening of an investigation, regardless of whether it ultimately results in trials against specific individuals and their conviction. The pre-trial chamber decided, however, that given, and I quote, the extremely limited prospect of successful investigation and prosecution, personal investigation would not contribute to achieving victims' interest. I note, Your Honours, with concern the pre-trial chamber's readiness to depart from the views expressed by victims as part of a process of victim representation, and to substitute its own assessment to said views. Effectively, the pre-trial chamber assumed that victims making representation were oblivious to the challenges the prosecution could face in the course of a potential investigation concerning Afghanistan. It decided accordingly that, contrary to their own representations, the victims' interests militate against the opening of an investigation which may not lead to conviction, in the words of the pre-trial chamber, creating frustration and possibly hostility vis-à-vis the court. The office rejects said paternalistic approach, which instrumentalizes the role of victims, oversimplifies their experiences and expectations, and underestimates their understanding of the justice process and of the broader geopolitical context. The pre-trial chamber also erred in finding that the interests of victims were either nullified or outweighed by competing non-legal factors, such as the feasibility of investigation and the proper allocation of the prosecution resources. From the perspective of a general interest of victims, the Chamber's reliance on the anticipated feasibility of investigation based on the passage of time since the crimes, the prospect for state cooperation, and the expected availability of evidence and suspects is erroneous. As the pre-trial chamber itself recognized in its subsequent decision granting leave, and I quote, according to the statute, the prosecutor is meant to act as the driving engine of investigations, enjoying exclusive responsibility when it comes to assess the feasibility of investigations. Is paragraph 24 of decision 62. The impugned decision's approach to the issue of feasibility is also deeply concerning for a variety of reasons. First, said approach signals to victims that for the court, the rights to truth, justice, and reparation are only worth pursuing where justice is within easy reach. On the contrary, we submit that the court's intervention is all the more fundamental in challenging geopolitical, security, and humanitarian situations, where the court effectively represents the victim's only hope to obtain justice. While on this topic, allow me to briefly address the submission made by the government of Afghanistan earlier this week and reiterated this morning. Said submissions concern primarily issues of complementarity which are not at stake in the present appeal and will be more appropriately addressed at a later stage of the proceedings. The government of Afghanistan addresses in detail a number of domestic reforms designed, in its words, to facilitate the investigation and prosecution of international crimes at the national level. To date, said reforms do not appear to have led to tangible results or meaningful progress in the achievement of the rights of victims who continue to look at the ICC as their only hope for justice. Second, the pre-trial chamber reliance on the prospect for state cooperation as a factor in the assessment of the interests of justice gives credence to criticism of the court as a politically driven institution. For victims, it means that their hopes of seeing justice before the court are effectively dependent on whether or not they happen to have been victimized by perpetrators supported by powerful states. Further, the pre-trial chamber's approach makes the opening of an investigation conditional on the prosecution demonstration that the prospect of success in a given situation are higher than in other situations before or potentially before the court. The interest of victims in the proposed Afghanistan situation and their rights to truth, justice, and reparation would need to be weighed against those of other victims of all other existing or potential situations before the court, placing victims of relevant crimes in competition with one another, contrary to the fundamental values enshrined in the statute. Finally, the pre-trial chamber's approach ignores that the international criminal justice framework as a whole is based on the premise that a given state's unwillingness to bring to justice the perpetrator of the most serious crimes does not mean that the victim's rights to truth, justice, and reparation for the said crimes should be infringed. On the contrary, international and hybrid tribunals established since Nuremberg have proved that it is possible and indeed necessary to respect victims' rights and hold accountable the perpetrators of the most serious crimes of concern to the international community, even where relevant states resist these efforts. As for the appropriate allocation of the prosecution resources, we agree with the views already expressed by the prosecution and counsel for victims to the effect that the pre-trial chamber abused its discretion in pronouncing of matter which falls under the prosecution authority. Budget constraints and the exigencies of key prioritizations are concerns the court share with other international and hybrid courts and with many domestic legal systems. These concerns do not, however, justify the wholesale denial of authorization by the pre-trial chamber. Finally, turning to question C, concerning the pre-trial chamber position on the scope of any authorized investigation, we submit that the majority of the pre-trial chamber erred in law in conducting its scrutiny of the interest of justice on the basis that an authorization to commence an investigation pursuant to Article 15.4 would be limited in scope to the events or categories of events identified by the prosecution in its request, as well as to those closely linked. The approach adopted by the pre-trial chamber in this respect is contrary to the requirements of efficiency, expeditiousness, and judicial economy, and precludes the prosecution from fulfilling its duties under the statute, including to establish the truth by extending investigation to cover all facts and evidence. It also marks a significant departure from the carefully designed balance of power between the prosecutor and the pre-trial chamber negotiated by the state bodies and set out in the statute. From the victim perspective,
Ms. Mancia, you have 2 minutes left.
Thank you. From the victim's perspective, there is of course a substantial interest in broad scope authorization, allowing for an investigation that duly encompasses the full extent of their victimization and the impact of the crimes on individuals and affected communities. The pre-trial chamber ruling on this point is at variance with well-established jurisprudence of the court in all Article 15.4 decisions adopted to date, including most recently in the context of the Bangladesh and Myanmar situation, where pre-trial chamber categorically rejected the approach adopted in the Poon decision as being contrary to, among other things, the object and purpose of Article 15 proceedings. According to the Pretrial Chamber in Bangladesh, Myanmar, the process of judicial authorization set out in Article 15.4 was intended to prevent unwarranted, frivolous, or politically motivated investigation. This objective is achieved as soon as there is a reasonable basis to believe that at least one crime meeting the relevant jurisdictional and admissibility requirements has been committed. To conclude, the Office's principal submission is that the pre-trial chamber acted ultra vires in reviewing the prosecutor's negative assessment of the interest of justice. In the alternative, the Office posits that the pre-trial chamber applied an incorrect standard in carrying out said review, took into account irrelevant factors, and misinterpreted and failed to have due regard to the interest of victims. Consequently, the appeal chamber should reverse the impugned decision and authorize the opening of an investigation, or remand the matter back to the pre-trial chamber for it to authorize the opening of investigation in the situation in the Islamic Republic of Afghanistan. This concludes, Your Honor, my submission in the general interest of the victims. I thank you.
Thank you very much, Ms. Masida. We will now hear submissions from the Amici Courier, beginning with the Office of Public Counsel for Defense. Your 15 minutes begins now. Please proceed.
Mr. President, Your Honors, please permit me to address you in French. Monsieur le Président, Mesdames,
Your Honours,
de la Chambre d'appel, plaise à la Cour.
may it please the Court.
La Cour pénale internationale devant laquelle j'ai l'honneur de
I stand
plaider
before the International Criminal
a été
Court,
voulu et créé
created
dans le but de
with the
déterminer la
purpose of
responsabilité
determining individual
individuelle
criminal
laquelle
responsibility
est assise sur
through
les règles
judicial
et
proceedings.
procédures judiciaires. Dans un tel contexte,
In such a context,
ces poursuites pénales doivent toujours reposer sur les
underpinning
droits des
such
personnes
criminal
qu'elles jugent
proceedings must
dans les
always
situations
be
qu'elles
the
autorisent.
rights of those individuals it will
Plutôt que de
try in
s'appliquer
any
au
situation
dernier
it
stade du
authorizes,
processus,
rather
le
than
droit
be
à un
applied
procès
at the later
équitable
stages
tel
of the
qu'il ressort
process.
des instruments
Fair trial
relatifs
rights,
aux
as
droits de l'homme,
derived from human rights
est l'un des volets
instruments,
fondamentaux
are
de
one
la
of the
justice.
fundamental components of
Les
justice,
principes qui en
and the
découlent
principles derived
demeurer
therefrom
le fil
shall
conducteur
remain
du
the
procureur
golden thread
qui s'oblige
of
à
the
n'envisager
prosecution's
toute
obligation
responsabilité
to
pénale
see any
présumée
alleged
éventuelle
criminal liability
qu'au-delà
through
de tout doute
beyond
raisonnable.
a reasonable doubt.
La CPI est ni une commission
The
d'enquête,
ICC is
ni
not
une mission
a
d'enquête
commission of
indépendante,
inquiry,
encore
nor
moins
is it
une
an
organisation
independent
internationale de
investigations
droit
mission
humanitaire.
or even an international
En
human
tant que
rights
juridiction
organization.
de dernier recours,
While a court of
Elle ne
last
devrait pas
resort,
être
it should
considérée
not
comme
be
une
considered
cour
a court
du
of
dernier
last
espoir.
hope.
La CPI est un organe
It is
chargé
a
par la
body
communauté
tasked by the
internationale
international
de ne
community
juger que les plus
to
responsables
try
des
only
crimes les
those
plus
who
graves
are
contre
the most
l'humanité,
responsible for
les
the
crimes de
gravest
guerre et
crimes against
d'agression,
humanity,
ceux
of
de
war
génocide.
and aggression and
C'est
of
une cour
genocide.
complémentaire aux
It is
autres.
one that lives in complementarity with other regimes.
C'est une cour complémentaire aux autres régimes.
It is
et
one
qui
that
ne
lives in
reste
complementarity with other
que des
regimes
questions
and
dont elle
only
peut
remains
connaître
seized
et qu'elle
of
peut juger
matters
de
that it
façon
can properly
appropriée
try
en exerçant son mandat dans les
within
limites
the
de sa
confines
compétence
of its
et de ses
jurisdiction
capacités.
and ability.
L'OPCD a régularisé les
The
écritures
OPCD
fournies
has
et
provided
détaillées qui
lengthy written
le reflet de nos
submissions that
convictions
go to the
et au
fundamental
cœur
core
même de notre
of what
conception
our
du procès
office
équitable
believes in.
pour tous les
That is
accusés
to
à
say,
n'importe
fair
quel
trials
stade
for all
procédural.
defendants at whatever stage of the
Autant le
case.
dire, nous n'avons aucun agenda.
In the present matter,
Dans la présente affaire ou
we have
situation,
no agenda whatsoever.
l'une des premières
And
phases
in
de
the
la
present
CPI,
matter, looking at one of
celle
the
de
earliest
l'ouverture d'une
phases
enquête,
of the ICC,
la norme
i.e. that of the
employée ne peut
opening
être
of an
inférieure à
investigation,
celle dite
the standards
standard.
can be none the less,
Surtout
or no
lorsqu'il
less.
s'avère
especially in that there are suspects who are known at this time. Even some of them were referred to this morning by the legal representatives. LRV 2 and 3. Now, to outline our submissions briefly today, the Appeals Chamber has invited the OPCD to provide amicus curiae to the Court on the merits of the appeal, and we thank you for this opportunity. I will therefore reference the questions the Chamber has put to us before the hearing. I will begin with question B, relating to the factors considered, and then move on to question A, and, where related, question C, on the powers of the pretrial chamber to consider such factors. Firstly, it is important to consider that the three factors listed by the pretrial chamber as considerations that are against the interests of justice in opening an investigation in Afghanistan, that is to say time, cooperation and evidence, are essentially those that go to the heart of whether defendants later appearing before this court will be able to receive a fair trial. More generally, the prosecution's recent report on the Kenya situation even goes so far as to recommend the core of these three factors as part of a consideration of the prosecutor's office in the preliminary examination process under a framework of what could be called a feasibility analysis. That report states that the OTP should consider the feasibility of investigating in the situation country, resources, witness protection, ability to operate on the ground. The stated purpose of the study was to, quote, learn from the experience, unquote, at the handling of cases, and with respect to these proposals, the OTP notes that, quote, OTP policy until now has been to not include the feasibility of investigating as a factor to consider at the stage of seeking authorization to open, unquote, but only much later at the stages of case selection and prioritization. What's been shown in that situation and others is that without such proper analysis, there is great potential to compound the harm in trying to achieve justice at all costs, where it is not feasible given a substantial lack of evidence. Contrary to the prosecution's assertion that passage of time was considered on its own, it is evident that the pretrial chamber assessed this factor in conjunction with the availability of evidence and cooperation, essentially concluding that a lacking on all three indicated that proper investigations would not be realistic. Without proper investigations into both incriminating and exonerating evidence, pursuant to Article 54(1)(e), fair trials can never be held. Essentially, without access to evidence, there will be no trials. Without trials, no justice. These considerations were confirmed only this week by the Afghan government, which gave alarming detail of the complexity and volatility of the current situation in Afghanistan, which poses real and substantial problems to any investigation. Citing specifically the ICC prosecution's failure to travel to Afghanistan and investigate activities itself, despite being invited to do so, based on the difficulties cited by the PTC. When a case falls apart, or a whole situation appears to be destined for that route, it is neither in the defendant's nor the victim's interests let alone that of justice. While the prosecution's submissions note that it is not only about convictions for the victims, recent history has demonstrated the real harm caused to victims when the wrong defendants are tried, and the court is incapable of bringing the proper suspects to justice based on an inability to collect proper evidence. Named defendants suffer harm merely for being summoned by the court. The lives of defendants are stopped short by virtue of being unjustly prosecuted, and the lives of victims are ruined without access to reparations from properly identified, charged and tried defendants. Those of us in the courtroom who are not in possession of the full, confidential underlying facts or evidence of the request, like the OBCD, must defer to the assessment of pre-trial chamber 2. In so doing, it came to that rare but possible conclusion, as outlined in the response, the LRV 2-3 response, quote,
on the basis that it was shown that a fair trial was impossible for any conceivable case within the proposed investigation. End of quote. Compte tenu de la norme opérationnelle,
given the operational standard of proof before this court, the burden remains on the appellants to demonstrate that somehow the pretrial chamber abused its discretion in assessing these relevant factors. Secondly, the pretrial chamber has power to consider factors itself. In a court of law, a chamber hearing the case is the ultimate guardian of fair trial rights. As the State of Afghanistan submissions eloquently outline in paragraph 8. In the matter at hand, the pre-trial chamber is the gatekeeper of proprio motu prosecutions by the prosecution. It is important to recall that during the discussions in Rome, because of the inability to agree on an investigating judge function as suggested by France, this pre-trial chamber was the compromise to create a stopgap measure on the possibility of an overreaching prosecutor. This is the only interpretation that is consistent with human rights law and the preservation of the chamber's powers to ensure fair proceedings before the court. Several amici in the proceedings have emphasized the need to consider international human rights law via Rome Statute Article 21, paragraph 3, and the OPCD would like to express its agreement, whilst underscoring that human rights law belongs to all humans and therefore such considerations must also take into account the human rights, especially in the context of a fair trial, of those who will face charges. LRV 2 and 3 as much as agree with the need for fair trial rights in the consideration of Article 21, paragraph 3 in this context. Therefore, it is within the remit of the pre-trial chamber to make such considerations in reviewing a request of the prosecution, having in mind the human rights implicated in its decision. Furthermore, the ICC, being a court that has the power to even evaluate the fairness of other due process proceedings in the context of war crimes, must present itself as a model of justice for the defendants it itself tries. Even if the appeals chamber finds that the Rome Statute grants sole power to the prosecutor to make an Article 15 interest of justice assessment, such human rights must underpin any such review of these requests by the pre-trial chamber. In many requests, the prosecution's submissions on interest of justice considerations are light, granting the pre-trial chamber alone the power of assuming proper analysis was done. However, in an effort at transparency and for a proper review, the Chamber must have the details of this analysis. Thank you. Must the details of the analysis so as not to substitute its own. This is supported also by the recent Kenya report, which advises the prosecutor against assuming that a situation will be granted and asks the prosecution to anticipate all legal and jurisdictional issues. For this, the prosecution must provide a clear iteration of its interest of justice analysis, including the human rights of suspects, for the pre-trial chamber to be able to make a proper review and take an informed decision. To say otherwise would strip the chamber of its power to ensure fair proceedings are brought before the court and make it, as noted by State Party Afghanistan, a mere rubber stamp on the prosecution's proprio motu investigatory powers. For the foregoing considerations and respecting the standard of appeal in play, if the appeals chamber does overturn the impugned decision, it should be remanded back to the pre-trial chamber for new determination based on the appeal chamber's holdings that, in this case, 1. The opening of a situation in accordance with Article 15 of the Rome Statute must consider the right to a fair trial and the human rights of any future defendants, and 2. These considerations must be clearly listed in the request of the Office of the Prosecutor and the decisions of the pre-trial chamber for a full accounting of transparent justice. Thank you very much.
Thank you, Mr. Keita. And now, I would like to invite the Council of the Jerusalem Institute of Justice, the International Legal Forum, My Truth, the Simon Wiesenthal Center, the Lawfare Project, and UK Lawyers for Israel. You have also 15 minutes.
Your Honours,
please.
Since its genesis, the interests of justice provision under Article 53(1)(c) of the Rome Statute, as properly construed, as related to whether the commencement of an investigation would be counterproductive. So understood, it encompasses broader considerations than simply criminal justice. Your Honours, it is not in the interest of justice, so understood, for the ICC to investigate the conduct of nationals of non-states parties absent a Security Council referral authorising the investigation. This, Your Honours, is the golden thread which underpins our answers to questions B and C of the Chamber's questions in Group C. Your Honours, yesterday the prosecution suggested that the issue of whether the court is permitted to exercise jurisdiction over nationals of non-states parties absent a Security Council referral is not an issue that fairly falls within the parameters of this appeal, and accordingly, quote, the prosecution will not be touching on the issue of non-states parties, end quote. In light of the prosecution's submission, I will turn to issue CC first in order to explain why we respectfully submit that Mr. Guariglia was wrong. It was noted that Mr. Guariglia yesterday specifically acknowledged, in response to a question from Her Honour Judge Ibanez Carranza, that this issue has a, quote, jurisdictional connotation, end quote, and it has specifically been raised as such by the legal representatives of the victims. Your Honours, not only does the issue of non-states parties squarely fall within the parameters of this appeal, it is also germane to question CC posed in the decision on the conduct of the proceedings. This question contemplates whether the prosecutor is permitted to investigate incidents proprio motu which a pretrial chamber has not specifically authorized. It follows that with respect to such incidents, that the pretrial chamber has not made a specific determination that they fall within the material jurisdiction of this court. The prosecution's appeal is also premised on the argument that the pretrial chamber's findings with respect to the scope of the investigation impacted its finding that there are substantial reasons to believe that commencing an investigation would not serve the interests of justice. Your Honours, this demonstrates that the scope of the permissible exercise of the court's jurisdiction is in issue in this appeal. No participant disputed this proposition yesterday, and indeed it was echoed by LRV2 and LRV3 this morning with respect to the scope of the investigation of the crime of torture. Ms. Reich submitted that among the most, quote, glaring errors, end quote, of the PTC was its misinterpretation of territorial jurisdiction. We therefore agree with LRV1 that it would be, quote, highly problematic if the appeals chamber were not to correct the pretrial chamber's errors with respect to jurisdictional scope, and that, and I quote from the consolidated response of LRV1 to the amici at paragraph 30, issues as to the court's jurisdiction should be resolved as early as possible in the proceedings, end quote. LRV2 and 3, in their joint brief, also explicitly invite the appeals chamber to address all jurisdictional questions which arise from the decision in the current appeal for reasons of judicial economy. Yesterday, the prosecution agreed with the OPCV that the appeals chamber is in a position to decide, quote, all the critical issues, regardless of whether Your Honours decided to go via the 82.1a or the 82.1d route. In our submission, the permissible scope of the exercise of personal jurisdiction is a critical issue, and the correctness of paragraph 50 of the impugned decision, where the pretrial chamber found that conducts that have allegedly occurred in full or in part on the territory of Afghanistan or of other states' parties fall under the court's jurisdiction, irrespective of the nationality of the offender, is critical too. As my learned friend Mr. Jacobs submitted yesterday, this finding is disputed. We submit that it was wrong, indeed, a glaring error, as put by Ms. Reich. If in error, it too would materially impact upon the scope of the proposed investigation and the assessment of factors which the pretrial chamber considered relevant to the interests of justice, including the prospects of state cooperation and for securing evidence and suspects. However, given that the issue was not fully raised on appeal by the prosecution, and it has not been, nor has ever been, properly litigated in an adversarial setting before this court, we submit that the appeals chamber is by no means in a position finally to determine this issue now. Your Honours, turning to issue CB, were the factors considered in paragraphs 91 to 95 of the impugned decision appropriate? We disagree that the pretrial chamber abused its discretion in paragraphs 91 to 95 of the impugned decision. On the contrary, the pretrial chamber was right to ground its analysis of the interests of justice in the overarching objectives underlying the statute contained in its preamble. Moreover, in addition to the objective identified in the preamble's recital 5, expressly relied on by LRV2, we submit that it was also open to the pretrial chamber to consider recitals 7 and 8 in the context of its Article 53(1)(c) analysis. These reaffirm that the purposes and principles derived from the UN Charter, including the principle of non-interference, and emphasize that nothing in the Rome Statute shall be taken as authorizing any state party to intervene in the internal affairs of any state, may be considered in this context too. It was therefore open to the pretrial chamber to find that an investigation can hardly be said to be in the interests of justice if the relevant circumstances are such as to make such an investigation not feasible and inevitably doomed to failure. Your Honours, we do not agree that the pretrial chamber's concerns with respect to the availability of evidence and the limited prospects of state cooperation were speculative or premature, given the public statements of senior United States government officials, taken together with the obstacles to investigating in Afghanistan raised both by the government of Afghanistan and LRV-1. We respectfully disagree with Ms. Brady that this was a decision, quote, made in the abstract, end quote. This also flows from the position that the proposed investigation contemplates the alleged conduct of nationals of non-states parties, which has not consented to the exercise of ICC jurisdiction, excuse me, which has made clear that it has no intention to cooperate, and which is under, and would be under, no obligation to do so should an investigation be authorized. Your Honours, it was therefore open to the pretrial chamber to find that the prospects of a successful investigation and prosecution, particularly of US nationals' conduct, were, quote, extremely limited. It is striking how the prosecution and the legal representatives for victims have dismissed this cold reality as mere speculation. But it was by no means ultra vires, unreasonable, or otherwise an abuse of discretion for the pretrial chamber to be guided by operational and therefore resource allocation considerations when undertaking an interest of justice analysis pursuant to Article 53(1)(c). To illustrate the point, in paragraph 126 of its appeal brief, the prosecution arguably misconstrues the nature of states parties' cooperation obligations with respect to the arrest of suspects, which may arise upon the commencement of an investigation, by suggesting that a state party would be in breach of its legal obligations if it declines to surrender a suspect pursuant to an ICC warrant. Articles 59(1) and 59(2) and Article 89(1) require specific consideration of the relationship between the Rome Statute system and national legal systems. This is because states parties' cooperation obligations remain subject to a residual discretion which the statute affords to them to determine whether an ICC arrest request is made in accordance with national law. In the UK, for example, common law writs of habeas corpus and abuse of process are reserved and will arguably, ultimately, override the effectiveness of Rome Statute cooperation obligations. The legal effect of the Rome Statute's cooperation obligations may therefore be considered as part of an assessment of whether an investigation would not be in the interests of justice, and it cannot be assumed that states parties, which ultimately do not surrender a national of a non-state party to the court, is acting in breach of them. We nevertheless agree with the prosecution that the materiality of any considerations other than the gravity of the crime and the interests of victims is to be determined on a case-by-case basis. In this situation, the principle of comity is, for example, an important principle of justice safeguarding the interests of peace and security in international relations. The Chamber may agree that the, quote, delicate mosaic referred to in recital 1 of the preamble, considered in the context of the complementarity principle enshrined in recital 10, incorporates this principle of justice into the Rome Statute system. The principle of complementarity is, after all, not confined to Article 17 and is regulated by the interplay of the preamble, Articles 1, 12, 15, 18, 19, 20, 53, and 95 of the statute. We therefore support the Islamic Republic of Afghanistan's core submission that the term the interests of justice should be interpreted in light of the importance of effective national investigations and prosecutions. Domestic investigations in non-states parties such as the United States, which may not strictly fall within a narrowly interpreted Article 17, may nevertheless reflect an exercise of jurisdiction by that state pursuant to its obligations under customary international law. As a matter of comity, should a qualified deference not be afforded to decisions of national courts in an interest of justice analysis pursuant to Article 53(1)(c), if made under, for example, an administrative or public law framework through which the legality of public bodies' acts is adjudicated genuinely by reference to obligations under customary international law. Considering the value, Your Honours, of systemic integration of international law, whilst remaining mindful of the plurality of the world's legal systems, as well as the aspirational nature of the ICC's universalist ambitions.
You have 2 minutes left.
Thank you. We would argue that it is not in the interests of justice for the ICC to assert that ICC jurisdiction has hierarchical superiority, or is even lex specialis, over national law decisions pronouncing on the legality of executive acts of state in the absence of any grounding for this proposition under general international law. The interests of justice oblige the court to be mindful that whereas between its relationship with states parties, framed in terms of the delegation model yesterday by my learned friend Mr. Jacobs, the system of cooperation under Part 9 of the statute is a self-contained regime. As Mr. Jacobs submitted, between the court and non-states parties, we must identify the specific rules of customary law that apply to that separate circumstance, and the ICC does not operate in a legal vacuum. For the record, Your Honours, to be absolutely clear, the position of the human rights organisations that we represent is that it would be a flagrant breach of natural justice were the court to allow this appeal based simply on the material before it. We therefore invite the appeals chamber, if minded to do so, to remit the issue of jurisdiction to the pretrial chamber or adjourn these proceedings before permitting argument from participants on the critical issue of whether the exercise of ICC jurisdiction over nationals of non-states parties is permitted. Indeed, in and of itself, this is a ground to believe that it would not be in the interests of justice to authorize an investigation in a situation which engages the rights of a non-consenting state absent Security Council imprimatur. Taken together with those factors properly identified by the pretrial chamber, as well as the government of Afghanistan, there are substantial grounds to believe that it would not presently be in the interests of justice to authorize an ICC investigation pursuant to the prosecutor's November 2017 request. Thank you.
Thank you, Counsel. And now I would like to invite the Counsel of the European Center for Law and Justice. You have also 15 minutes, please.
Thank you, Mr. President, Your Honors, and it's again a pleasure to appear before you today. The pretrial chamber's decision that it was not in the interests of justice to authorize an investigation in the situation in the Islamic Republic of Afghanistan was based on the following three considerations, among some others, but these are the main three. The fact that significant time had elapsed between the alleged crimes and the request, the likelihood that relevant evidence and suspects would no longer be available, and the lack of cooperation obtained by the prosecutor. The prosecutor argued that these are broader considerations that did not need to be analyzed in this instance. We disagree, because the lack of cooperation in this case was actually based on general principles of customary international law and specific treaties between the United States and the Islamic Republic of Afghanistan. In her appeal brief, the prosecutor argued that the pretrial chamber was wrong in prejudging or speculating about the prospects for state cooperation. In paragraph 126 of her appeal brief, the prosecutor contends that some evolution over time may occur concerning the cooperation of state parties which are not parties to the statute. That is simply not the case regarding the United States. The United States has repeatedly and forcefully explained why it will not cooperate. As early as 2002, the United States Congress passed explicit legislation with wide bipartisan support the American Service Members Protection Act, codifying into law that it will not participate under Section 7423B of the Act, and I will quote, "No United States court and no agency or entity of state or local government, including any court, may cooperate with the International Criminal Court in response to a request for cooperation submitted by the International Criminal Court pursuant to the Rome Statute." There is no room to speculate that this will suddenly change. Non-cooperation by non-state parties non-party states is firmly grounded in customary international law. Article 12.2a, which purports to establish this court's jurisdiction over nationals of non-party states, does not comport with the customary rule reflected in Article 34 of the Vienna Convention on the Law of Treaties, which states that, and I quote, "A treaty does not create either obligations or rights for a third party without its consent." This court's jurisdiction is based on the delegation of authority by state parties. However, there is no customary norm whereby states can delegate their criminal jurisdiction over foreign nationals to a third party. In fact, the customary norm is just the opposite. Such delegation is unacceptable. A state's criminal jurisdiction over foreign nationals is a bilateral issue between the state and the accused person's state of nationality. A state cannot delegate that jurisdiction to another state without the consent of the accused states of nationality. A state also cannot delegate its criminal jurisdiction over foreign nationals to a tribunal whose jurisdiction has been rejected by the accused person's state of nationality. For such a delegation to be recognized as a customary norm, it would require a widespread consensus of states. No such consensus exists. In fact, approximately 1/3 of all states do not accept this court's jurisdiction over their nationals. Hence, by definition, this is not a customary norm, and the state parties to this court have no authority to impose it upon the rest of the world. Consequently, Article 12.2a of the Rome Statute is either ultra vires and void, or in the alternative, it must be interpreted as being consistent with existing international law, which is to say that a prerequisite for jurisdiction over nationals of non-party states is the consent of the individual state of nationality or a referral by the UN Security Council. Certainly, the exercise of jurisdiction over nationals of non-consenting, non-cooperating state is a legitimately contested issue, and an attempt to impose the court's will against states that are acting according to customary norms does not accord with the interests of justice. We further submit that it is not in the interest of justice to proceed against United States nationals in this matter because Afghanistan has no jurisdiction to delegate to this court as it relates to the United States, having previously ceded that jurisdiction in a series of international instruments known as status of force agreements. They're also known as SOFAs. The legal representative for victims 2 stated that the Islamic Republic of Afghanistan, in their submissions, has made no representation about taking legal actions against U.S. military personnel. The truth is, under these bilateral agreements, multilateral agreements, the interim security force agreements to Afghanistan, that jurisdiction rests with the nationals. In this case, in talking about the United States, of course, it would be the United States. On January 4th, 2002, the Interim Security Force to Afghanistan, commonly known as ISAF, signed a comprehensive agreement with the interim government in Afghanistan. Section 1.3 of the agreement's annex states that ISAF and supporting personnel, including associated liaison personnel, will under all circumstances and at all times be subject to the exclusive jurisdiction of their respective national elements in respect of any criminal or disciplinary offenses which may be committed by them on the territory of Afghanistan. The United States was a member of that group. Afghanistan also entered into bilateral state-to-state agreements with the United States, affirming that Afghanistan ceded exclusive jurisdiction over United States forces to the United States. The first agreement was a series of bilateral diplomatic notes that took effect on September 26, 2003. Second, Afghanistan entered into a bilateral security agreement, known as a BSA, with the United States in September of 2014 that effectively continued the ISAF agreement's terms. Notably, the pretrial chamber failed to even mention the ISAF agreement. In paragraph 59 of its decision, the pretrial chamber also incorrectly labeled the entire bilateral security agreement as an agreement pursuant to Article 98. This was incorrect. Article 98 agreements only cover the surrender of persons to this court. Both the ISAF and the BSA are much broader in scope because they also gave, again, exclusive jurisdiction over United States personnel to the United States. For the record, Afghanistan also has had Article 98 agreements with the United States, which went into force on August 23rd of 2003. So there was also an additional Article 98 agreement. Notably, the ISAF agreement predates the court's jurisdiction in Afghanistan. When Afghanistan joined this court in May of 2003, it did not possess jurisdiction over ISAF personnel, including United States forces, and hence could not have delegated such jurisdiction to this court. In paragraph 46, footnote 47 of the prosecutor's request for authorization of an investigation, the prosecutor asserted that whilst a SOFA might constitute a decision by a state not to exercise enforcement jurisdiction, such an agreement does not extinguish a state's prescriptive and adjudicative jurisdiction. This claim by the prosecutor is entirely unfounded. The agreements are explicit in granting exclusive jurisdiction. Regardless, it is neither the place of the prosecutor nor this court to interpret how much jurisdiction the Afghan government ceded to the United States. The authority to determine such issues is limited to the parties to the agreement. Article 34B of the Vienna Convention expressly provides the default rule for situations such as this one, the attempt to impose a multilateral treaty obligation on non-party states. And I quote, "The treaty to which both states are parties governs their mutual rights and obligations." This provision embodies the bedrock principle of lex specialis, and in this instance, the bilateral jurisdictional agreements between Afghanistan and the United States are the lex specialis that govern their relationship. To conclude, the prosecutor wants this chamber to overturn the pretrial chamber's interest of justice analysis, in part because she thinks the United States may yet decide to cooperate. We submit that this ignores the history of principled non-cooperation under multiple administrations of multiple parties in the United States, as well as explicit official public statements and long-standing legislative acts which say that the United States is not going to cooperate based on customary international law and specific bilateral agreements. This analysis is relevant because the impugned decision was made and based on the interest of justice. It is not in the interest of justice to ignore customary international norms. It is not in the interest of justice to override explicit agreements between sovereign states. And it is not in the interest of justice to waste the court's resources while ignoring the reality of principled non-cooperation. Thank you again for granting me leave to appear, Your Honor.
Thank you very much, Counsel. We will now hear questions from the bench. I will now give the floor to my colleagues, beginning with Judge Howard Morrison, who would like to ask the question to Mr. Dixon. Please.
Mr. Dixon, would you propose that the aspirations underlying the complementarity provisions envisage a stark and perhaps mutually exclusive choice between the ICC and national investigations and or prosecutions?
Thank you, Your Honour. The submission of the government is exactly not that. If the national jurisdiction is investigating, which we say is going on, and we've presented evidence of that, specifically of what's happening in the last 2 years, the period since the prosecution applied, then it is for the court to step back under the principle of complementarity. But that doesn't mean that the government then goes off on a tangent. What we are specifically saying, and this is highlighted in our submissions, is that given the point where we are at, the government would undertake to continue to report to the court, in particular the prosecutor, on the steps that it's taking, akin to the procedure that is in Article 18. We're not there yet, but there's a procedure there where through deferral, the state, certainly after the first 6 months and thereafter, would report to the prosecutor so that the prosecutor can consider whether or not genuine progress has been made. And if such progress hasn't been made, then it's always open to the prosecutor, as was highlighted yesterday, to make an application to authorize, as is provided for in Article 18 as well. Now, we're not at that stage yet, but what we are saying is it can readily, and it should be applied right now, that those investigations that are ongoing should be allowed to continue with proper reporting and cooperation with the Office of the Prosecutor. If there's any deficiency which requires the intervention of the court, following consultation with the state, there are then procedures whereby the prosecutor can apply and bring it back to the ICC. So it is one where the state and the ICC are in harmony, as I emphasized, working hand in hand. If, of course, the ICC has to take over the cases, then it will have primacy. That doesn't prevent the state from, at a later stage, applying to take the cases back. But what we are saying is that's far down the line, it's speculative. In our submission, it should never arise because the national jurisdiction is investigating, will do so. And what we are asking for is more recognition and support for that from the court and from the Office of the Prosecutor. Hence the application that we are making, or the submission we are making, which is do not authorize, or in the alternative, revert it back to the pretrial chamber to consider these matters, taking into account all the new information and submissions that we have made, together with all the other parties in the proceedings.
Thank you. Even absent complementarity, can we not consider the way the ICTR and the Rwandan courts, including the Gacaca courts, operated in parallel at the same time?
In the context of the ICTR, which was a Chapter 7 Security Council mandated court, which had primacy, it didn't have a complementarity regime. That court continued to exercise its primary role throughout. And yes, the national alternative justice proceedings continued. But we submit we're not in that paradigm here. We're in a genuine complementarity regime where the state must be given the first and full opportunity to investigate and prosecute. As I say, not going out on a limb, working in tandem with the court. But the court can only take over if, upon a proper application from the prosecutor, an investigation is then authorized. And we are saying we're not there yet. Let's not do that now, when further down the line that might still be possible. Give the state an opportunity, particularly in light of the evidence that we've submitted to your honours.
And one question for Mr. Sekelo. You've confined your arguments and remarks for the main part to position of the United States, and particularly the bilateral treaties. What of states other than the United States of America who have security forces in Afghanistan, some of whom are signatories to the Rome Statute?
Well, first, there are governments that are signatories to the Rome Statute that are also part of the interim security force agreements. If there was a conflict between those, that would be different than in a situation in the United States. The jurisdictional grants, or the ceding of jurisdiction, was a negotiated issue. And there was additional, that's why I'm saying it's not just the international security force agreements. We had bilateral in the United States, had bilateral. And other governments may well have too. But in a situation that we have, it's clear that there was no jurisdiction for Afghanistan to cede to this court. If they were in fact parties to, it would be almost the opposite of lex specialis, if in fact they were bound to a multilateral treaty like the Rome Statute. But that's not the case for the United States. And I should add that the annexes to the agreements are different for some of the various countries. So that's why I was speaking specifically, Your Honor, towards the United States.
Now, I understood that, but there is, of course, for the court, the dichotomy that there are some states who are not in exactly the same position as the United States.
Well,
the arguments of the United States might well be made theoretically if there was a prosecution and United States citizens were indicted, then those arguments would be no doubt raised very thoroughly by the United States again. But the court has to recognize that we are dealing with a multiplicity of players and not simply one country.
Well, that's correct. But the agreements themselves specify this ceding of jurisdiction. For instance, as it relates, again, to not belabor the point, as it relates to the United States, it is an exclusive grant of jurisdiction from Afghanistan. Other countries, it may not be. So if there's a conflict, customary international norms you would determine based on interpretation statutes of treaties how to handle that. In this case, lex specialis would be clear, but it's also clear that the Afghanistan did cede exclusive jurisdiction to the United States. Thank you.
Thank you very much. And now please, Judge Ibanez, 2 questions.
Thank you, Mr. President. My first question goes to the representative of the Islamic Republic of Afghanistan. Please, in your submissions, in your written submissions of 2nd December this year, you stated in paragraph 7 that Afghanistan is also in a unique position to verify the pretrial chamber conclusion that the complexity and volatility of the current situation of Afghanistan poses real and substantial problems to any investigation. Then in paragraph 29, you state also that indeed the attacks against judges, prosecutors, and police have continued and worsened. The UN Secretary General noted that in 7 August 2019, there was a complex attack by anti-governmental forces to police headquarters. You also noted that on 7th September 2019, there was the killing of an appellate judge, and also that there are a lot of Taliban attacks against judges, police killings, and so on and so forth. If it is the current situation of Afghanistan, how can you say that the state has the ability to investigate and prosecute the crimes of the case at stake? Please, thank you.
Thank you, Your Honor.
The representative, maybe, because this is political, but if you want, you can answer.
If I could give an initial response,
Okay.
and then ask the ambassador if he wishes to add, I'm sure he may wish to. To reiterate what the meaning of our submission in writing was, and hopefully which I've clarified today, what we are making clear is those realities on the ground. In the various efforts to go into areas, in particular that are volatile or may not be under the control of the government, as was highlighted by the victims, these kinds of problems have been experienced. But what we are saying is the genuine and fearless efforts of the government to do that should be recognized, that they are trying to, however difficult it is, ensure that there are investigations and prosecutions within the country. And we shouldn't overlook that there have been successful prosecutions and convictions. The establishment of the International Crimes Office in May 2018 is now seized of a number of cases that are being investigated, where in those cases, most of them are proceeding. There haven't been incidents where investigators have been killed or prosecutors or judges killed. So there are success stories as well. There's a recent report which we've also referred to from the UN in June of this year, where they indicate because of certain convictions that have taken place, there is a willingness on the part of the government to investigate and prosecute. So it's not one or the other. There have been success stories. There are bound to be difficulties nevertheless. But what we are trying to set out is the means that we are using to counter that. And that's where the plea for assistance is coming from. Recognize that and assist, because that is happening. There's going to be no delay in these proceedings going on, and whether we're going to have another investigation at the ICC that might be open for a long time before something happens. These cases are going on right now. So support those cases is the plea that we are making. And I think it should also be emphasized in addition to that, that the same difficulties that are faced by the government will certainly be faced by the ICC as well. If they haven't been prepared, the Office of the Prosecutor recently, since 2017, to go there, how is it going to be possible to take on those investigations? Many have submitted today that that's the solution, but they haven't actually explained, well, how are they going to do that? We're doing it at the moment. These are the problems we're facing. I don't see how the ICC could be in a better position. And our submission is that the government can do it quicker. It can do it now. No need to delay any longer. And it can be monitored. If there are problems, well, then the prosecutor can come back, is our submission. I hope that assists. And I'll see if the ambassador wants to make any further submissions. Thank you, Honor.
Maybe before of that, maybe I would like to complement with a follow-up question. Okay. Could you assure, but this is for the legal representative as well, yeah. Could you assure that Islamic State of Afghanistan is prepared or is able to cover the broad scope of the crimes that are at stake in this case before the ICC? Is the state able to reach all the perpetrators or possible suspects of all the crimes that are at stake on this case before ICC now?
Yeah. Thank you very much. First of all, I want to emphasize that what we submit in our submission, we have tried to project the reality of Afghanistan situation. Because the people were abroad and we are sitting in our very nice offices, warm, no the obstacle for our security, then it is easy to talk about those places which we never be there. In our submission, and the reality of Afghanistan is that it is 2 decades that we struggle with all of these obstacles and problems. But it is, and I should mention that, fearless efforts. This is the Afghan nation that inside the conflicts and the proxy war of many countries, still we live and we are ambitious to bring peace, and we have ambitious to work for our people and to develop the country. In these circumstances, beside all the responsibility that our government has, we also bring, as we committed to ICC and to international treaties, we bring reforms to our judiciary system since 2016, when our delegation at meet the prosecutor here in The Hague, they work on a roadmap of cooperation. Based on this work roadmap, to bring the reform in judiciary system, to amendment the criminal laws, to approve the torture laws in Afghanistan, which all of these new laws addresses the international crimes. In this situation, if there is no ICC, we as a state, we have responsibility for our people, and we do what we can do. We already do, we have thousands of cases under investigation. If you look at the prisons throughout Afghanistan, there are many people, they are now in the prison who are committed war crimes or other kind of terroristic crimes. So it means that in case of ICC investigation, it is the state that work with ICC. If the ICC could not visit this country and sit the security concern, in case of a certain investigation, it will take 4 decades more to have the results. So it is better to support the national judiciary system, and it is much on the benefit of the victims and the benefit of our national interest, that because we know our situation much better, the peace building, peace talks is much important for us. If we cut the current conflict through bringing the peace, as I mentioned in my speech, in the 9 months of this year, the number of civilian casualty was 8,000. At least we can save the life of these people. And mostly the justice can come properly in a country not in conflict time, but in post-conflict. Because of this, in current stage, we prefer that our national judiciary system continue what we can do, because on those areas that we cannot do anything, ICC also cannot do anything. We should talk what is the reality on the ground. One is what we dream, what we wish, but what is the reality? And if we increase the expectation together with ICC, and we cannot do anything for the victims, then how we can answer for those people after spending time? So because of this, in our oral submission, in our written submission, we emphasize that Afghan national judiciary system is much useful and better for this state to continue and investigate all those cases which is under the jurisdiction of ICC. Thank you very much.
There is a question for...
Yes, Mr. President. I actually have some brief remarks with regards to this subject. I can wait until tomorrow, obviously. However, if it benefits the court, and given the fact that the subject has been raised, and it does relate to the 2 questions that were just asked by Judge Carranza and Judge Morrison, I can make a brief remark with regards to the comments made by the government now.
For tomorrow, the same subject will be considered by the court, and I think it will be the time just to address the court tomorrow according to the schedule we have. Thank you.
Thank you. This question goes for Mr. Segula.
Yes, Your Honor.
You have talked about a principle coming from customary law, the principle of non-cooperation. In light of that, and in light that the prohibition of torture is a jus cogens norm, which under the provisions of the Vienna Convention and treaties has the highest hierarchy, and it's mandatory for all the countries, these kind of norms cannot be disregarded, and of course, coming from this hierarchy emerges a lot of obligations, erga omnes, to investigate and to prosecute. That said, do you think it is possible to reconcile this high hierarchy positioned norm, jus cogens, to prohibition of torture, with the so-called principle of no cooperation of states? Of course, I will need maybe a kind of academic response because you are not the representative of any state.
I am not.
Okay?
I am
Thank
not.
you.
To be clear, thank you. What we're saying, first of all, is that it's not a principle of non-cooperation. It's principled non-cooperation. In other words, that the United States, through its many administrations, through its policy statements, through the issues that have been raised even recently, have expressed consistently concern over jurisdiction of this court over non-member states. That would include nationals. I also think it's important, and I didn't want to spend time on it today because I'm conscious of the court's time, that the United States has a very comprehensive military justice system and a very comprehensive criminal justice system. And these cases that do arise from time to time, and it's interesting because the Office of the Prosecutor relied primarily on published documents from the Senate Oversight Committee, House Oversight Committee, that have reviewed when there's been issues. So what I'm not saying that the United States or any other country is immune from something not going as planned or for something to take place that would be a violation of international law. But I'm not willing to concede that the only way to handle that would be for jurisdiction of this court for a non-party state, which is in the situation in the United States. But I do need to say again, I'm not representing the interests of the United States here. Thank you.
Thank you very much. Judge Kim Prost, please.
Thank you. My questions are for the OTP, Ms. Brady. And they're interrelated to the argument advanced today and in your brief, starting at paragraph 35, this argument on the mandate of the pretrial chamber, or even obligation, as you express it in your brief, to consider interests of justice. And my first question relates, this argument seems to be premised on some form of intentional cross-reference between the chapeau of 53.1 and Article 15.4. And I'd be interested in your comments on 2 points in relation to that argument. First, the one already identified by OPCV, which is the blatant inconsistency between the wording of Article 15.4 and 53.1. And secondly, the drafting history, with which you are well familiar and is the subject of many commentaries, which supports that the articles were in different parts and negotiated in completely separated fashion. So I'd appreciate your comments on how your argument is in any way reconcilable with those 2 factors.
Well, Your Honor, our answer in relation to, I think I was making the point in relation to Rule 48. And Rule 48 is clearly for the OTP, and Rule 48 says that the OTP, the prosecutor, must consider all the factors in 53.1a through c. That was a clear link. And my submission was, in effect, that it would be rather illogical if the prosecutor's assessment in Article 15, for Article 15.3 for her request were to be based on those three factors, and yet when it comes to the pretrial chamber's assessment in Article 15.4, it was not based on those same factors when they're connected. I think the point I was saying is that when they're connected by the term reasonable basis to proceed, which appears in both Article 15.3 and Article 15.4. Now, I do realise, as you point out, that the drafting of Article 15 was quite separate to that which was going on for in the part of the statute on Article 53. And I don't want to say never the two shall have met, but they were drafted by different parts of delegations, and clearly when drafting the Article 53, the decision was taken in relation to when there is a state party or a Security Council referral, then how would that work in terms of the negative decision? So the question really arose, and I'm going back into my memory cells here, in the drafting of the rules and how that connect would be made. And to the best of my recollection, the link was made through Rule 48 on Article 15.3. But I was reminded when I heard the submission made by Ms. Sita, and Harkin Freeman has said that the reason why there's no express, if I understand her correctly, and I haven't read that chapter for a while, but from what I understood, the reason why 48 does not actually have an express reference to 15.4 is to keep them separate. Your Honor, that is not within my memory, and I am just approaching it as a point of view of interpreting on its face the standard which is in 15.3, the standard which is in 15.4. They're both on reasonable basis to proceed, and therefore, and looking at the case law, the consistent practice, where the pretrial chambers have looked at factor number C, that putting that together, it would suggest to me that they have some oversight role on the prosecutor's discretion. But as I said, it is a limited role, and that's very key to our submission. It's not that they can willy-nilly take into, pluck out a concern that they have not, that has not been raised by the prosecutor, and that's why we made the submission that it must go back to the prosecutor for her assessment, because it's fundamentally her discretionary decision which is oversighted by the pretrial chamber. Thank you.
The second aspect of your argument I understand completely, but just one follow-up question then with respect to, and I'm glad you raised Rule 48, because I'm also a little unclear on that, because this is a rule that was drafted after the statute was completed, so the two sections were well known, the content of them. It is in Part 3, so it is not in any way restricted to the prosecutor. It applies to Article 15 as a whole. It is clearly, I would suggest, identifying a lacunae, which is that there was no cross-reference between 53 and 15. And in those circumstances, if the intent of the drafters was to give a mandate to the pretrial chamber to look at interests of justice, why didn't they say it? Why didn't they refer to paragraph 4, and why didn't they refer to the pretrial chamber? That's where I don't understand why you're using 48 to support that it was intended to import interests of justice to the pretrial chamber.
Well, Your Honor, I'm not sure whether I can take the answer much further, because you're right, there's no explicit, we don't have Rule 48 bis, which says the determination of a reasonable basis to proceed under Article 15.4. So you could say that by its exclusion, the drafters felt that it was sufficiently covered. It was the field was covered, so to speak, by Article 15. And that's why, at the end of the day, the prosecution actually sees merit in the position put by the legal representatives for victims. And we've been very guided, I have to say, in our position, yes, by the rules, by the statute, by what we see as the wording of the statute, by what we look at in terms of the history of that drafting, what we can still sometimes vaguely remember about that, or better still. But we are particularly guided by the fact that you have 5 pretrial chamber decisions, and I think there is not quite the Kenya decision is could be interpreted either way. I have to disagree with Mr. Malombi that there are certain paragraphs in the Kenya decision that would suggest that all 3 paragraphs would have to be looked at, while there is another paragraph which suggests the opposite, and then there's a dissenting opinion of Judge Cowell which says, well, I agree with the majority, all 3 subparagraphs have to be looked at. So looking at this as a whole, we put together from what the pretrial chambers have decided, together with our understanding of the rule. But you're right, the rule happened after the statute, so the statute would have to reign supreme. Thank you.
Thank you very much, Mr. Brady. The schedule for day 2 of the hearing is now complete. The hearing will resume tomorrow at 10, not at 9:30 as planned before. Although the legal representatives of victims will not address the court, tomorrow all the counsels are invited to join us tomorrow in the courtroom.
Thank you. Mr. President, could I make one oral request, please? Previously, Your Honour's order before you amended it today provided for each of the LRV teams to have 20 minutes to respond, followed by final submissions of 10 minutes. I understand that you had vacated the final submissions of 10 minutes, but I did want to ask that if you have decided to vacate the response of 20 minutes also, we do have certain submissions to make in response to the submissions of the government of Afghanistan, as well as some submissions made by Mr. Sekulow and Mr. Curran.
Thank you, Councillor. Thank you, Council, for your intervention. The decision is positive, but of course the details will be expressed in the morning before we start to hear submissions.
I'm very grateful, Mr. President. Thank you.
Thank you very much. Well, last but not least, I would like to thank you all participants, of course all the court officers, interpreters, reporters, as well as the technicians for the security, for assisting us today. Thank you, all of you. The hearing is now adjourned.
All rise.